I don't know if we're dealing with just the issue of the stay or if we're dealing with the entire case.
We're dealing with both.
Okay. So, I guess where I started to say, I don't believe that the authority has made its case. I don't believe that there's an evidence been presented to support, again, the fact that the committee made its determination. There is no evidence. The authority has essentially, or plaintiffs have essentially admitted that the only evidence, quote evidence, was the request from the authority. And if you look through that request, it's not evidence. There's nothing even, there's not even any assertions of evidence. It's just saying, we want the bonds, please issue the bonds. And that's not evidence. But just a request, a bail request is not evidence. And the way they would look at it is saying that just the fact that in essence they're saying there is no way you can turn this down. And yet the statute specifically asks that the committee determine whether or not it is necessary or desirable to issue the bonds. Well, number one, if all they needed was a request and they would issue the bond, they wouldn't even put in that necessary or desirable. And they certainly, if they didn't think it was possible to turn it down, they wouldn't put in or not. So there had to be a weighing of evidence in order for the committee to make a determination of whether it was necessary or desirable or not. And there was no evidence. And so how can they possibly make a determination based on no evidence? And I'd like to, I should say, we have several parts to our presentation, and we're going to try in the interest of efficiency and minimizing the amount of the court's time that's involved in this. We split it up into three parts to the presentation. I'm going to be giving the first part of the presentation. Ms. Ross is going to be giving the second part, and Mr. Carlson will be giving the third part. I'm going to be basically talking about the lack of evidence to support the determination. Ms. Ross is going to be talking about the violation of the purposes of the bond, and Mr. Carlson is going to be talking about the violation of issues around the Public Open Meeting Act. So I'm going to quote from a case that is really the seminal case on the question of what evidence has to be presented under a 1085 proceeding for an administrative decision. And that case is California Hotel and Motel Association versus Industrial Welfare Commission, 1979. The site is 25 Cal 3rd, 200. And the portion I'm going to cite is on page 212. And there are two sections. One is, let me quote from this. A court must endure that an agency has adequately considered all the relevant factors.
Hold on a second. No flashes. You're distracted. Thank you.
Sorry. A court must ensure that an agency has adequately considered all relevant factors and has demonstrated a rational connection between those factors, the choice made, and the purpose of the enabling statute. And then the court inserted a footnote, and I think part of that footnote is extremely relevant to what we're thinking about and considering right now. Let me read that part.
Quick footnote number?
It's footnote 30. And again, it's on that same page. The precise formulation of the standard may be less important than what courts actually do in exercising deferential but not perfunctory review. What matters is that judges generally understand that they may not properly substitute their judgment for administrative judgment except on questions of law on which they are the experts, but that something like reasonableness, rational basis, substantial evidence, or clearly erroneous guide what they do on other questions. And that in most cases, other factors have a much stronger influence than the words of the formula that is supposed to apply. Whatever the formula, good judges customarily tread lightly when they are impressed with the care, conscientiousness, and balance of the administrators. But they penetrate more deeply, sometimes even substituting judgment, that is to say, sometimes even using their independent judgment, when the administrative performance seems to them to have been slovenly. So really what this is saying is there's a two-part test in terms of is the evidence adequate. The first part is looking at what was the nature of the proceedings. How did the administrative agency, or in this case the committee, how did they deal with this request to authorize issuance of bonds? So the first thing is the court has to ask, was the committee's deliberation careful, conscientious, and balanced, or did it tend more towards a careless and slovenly approach? And then, based on that determination as to what type of approach did the committee use in evaluating the court request, the court has to evaluate the decision itself. Now, if it finds that the process was in fact conscientious and careful, and there was a lot of consideration and balancing of the factors and the evidence, then the court has to be deferential. It has to show due respect for the committee's presumed expertise in its care and its decision making, and essentially say, you are the ones that are the experts here. I'm just reviewing this, and it seems to me you did a good job, so your decision stands. But if the process was slipshod and slovenly, then the court has to carefully consider whether the decision was really supported by the evidence that was before the committee. And again, depending on the degree to which the committee was careful, or the degree to which the committee was slovenly, the court may have to probe more deeply and really look at the evidence, and in fact, we think in this case, use its independent judgment of that evidence to determine does this really support anything. So let's look at what are the facts about the process here. Well, the first thing is the observation in paragraph 2 of the Declaration of Kathy Hamilton that none of the statutorily designated committee members were present at the meeting. Each one had named a substitute. Now, the named members of the committee, we agree that those people all had presumed expertise on different aspects of the whole case and the process, the decision that they were going to be making. And if those principals had actually been there, there would have been a reason for the court to defer to their expertise. But in fact, they all named substitutes, and we know nothing about the credentials or the expertise of these substitutes. There's nothing in the record before the court about who these people were, other than one was an assistant treasurer, but whether she even had any involvement in bond issuance, we know nothing. We know nothing about these substitute members of the committee. We know nothing about any expertise, any credentials, any past experience. Zero. So we can't rely on their expertise in deciding whether the decision was properly made. Second, on paragraph 3 of the Hamilton Declaration,
can the court rely on the fact that you accept that the original members at least were experts, and that they then had expertise to appoint the substitutes?
Well, they may have expertise in terms of making, deciding, well, maybe this is the most appropriate person, but then what if that most appropriate person isn't there? We don't even know anything about the process by which these substitutes were chosen. It may be, for example, let's say, with the High-Speed Rail Authority, it may be that they decided, well, we think this would be the best person, but they're on vacation. Well, then there's this person, but they're actually away from the office right now. This person has got to be someplace else. All right, this person's around. We don't know anything how they chose these people.
But what we do know is that the individuals who are on the committee, they have a certain measure of expertise. And those individuals have identified their substitute to be present at the meeting. Why shouldn't the court defer to that choice of the substitute? You have individuals who are experts, you can see that. Why shouldn't the court accept essentially their expertise and give them the benefit of the fact that they've actually designated someone who's also ostensibly expert in the issue?
Let me take a parallel situation. Let's say I wasn't able to be here today, and so I asked another attorney to specially appear on my behalf. Now, it may be I could find somebody who was equally skilled and equally aware and concerned about this case, but that would be pretty hard. And yet, if I couldn't be here and there was a need to have someone here, I'd have to find someone. And that someone might be someone who would basically come up and say, I really don't know much about this case, but Mr. Flashman asked me to appear especially on his behalf, and so I'm here. And how much expertise can you expect out of that attorney who really doesn't know much of anything about the case?
Well, less, but that does not necessarily mean none.
It doesn't necessarily mean nothing, but can one rely on the expertise of that person knowing nothing about how much they know? And none of these people made any statements even about what they knew, why they felt confident.
But to take your example one step further, you obviously are very knowledgeable about this particular case, the topic you've been involved in it for a number of years. If you weren't present, and you know the importance of the appearance, isn't it reasonable to assume that you would have designated someone to appear on your behalf who also is relatively knowledgeable? Maybe not as knowledgeable as you, but someone who at least does have a measure of expertise.
I would certainly try. That doesn't necessarily say I'm going to succeed. And we don't know how these people got appointed. In other words, if in fact each of them had a specific deputy that knew this bond issue pretty well, and they appointed them and they wrote a letter saying, I'm appointing this person because I think they're the best person to be here when I can't. We have at least that in the record. We have nothing in the record.
Can the court assume that, though, to some extent? Can it provide at least a measure of deference to those individuals because of the fact that they hold that position, they are the experts? Should the court at least give them deference with regard to their appointment process?
Well, they're experts in the process. I'm not sure that they're experts on appointments. The appointment of a substitute is not something that, this came up fairly quickly. The notice was only issued a couple of weeks beforehand. So they are limited as to how much they can, basically reach into their stable of people and say, you're going to appear because that person may not be available to appear. And so they're essentially, and we don't have any, there's no evidence as to what process did get used. So we don't know whether they in fact grabbed the person who was most eligible and said, you're going to go there, and they said, okay. Or whether they said, you're going to go there, I can't do it. You're going to go there, I can't do it. You're going to go there, I can't do it. And they reach down to the fourth or fifth tier to somebody who really knows very little about the case, little about this particular issue. And yet, they were the ones who could come. And so they said, okay, you're the last person I've got, you go. If we had something in the record to indicate how these people were chosen, that would be a different matter. But again, we don't. So, the third point has to do with what was the evidence actually presented at that meeting. And there were 4 people who spoke at that meeting. And 3 of those 4 made, I think, fairly strong cases as to why it wasn't even necessary or desirable to issue the bonds, to authorize issuing the bonds at that time. The 4th one, this is David Schweigel, spoke generally in favor of high-speed rail and why, the cost of this system made it a bargain. But he didn't say anything, provided no evidence as to why, at that time, authorizing bond issuance was necessary or desirable. He basically just says it's a good project. And then at the end, I think he said something like, go for it. But that's not evidence. Just saying go for it is not evidence. That's essentially what the High-Speed Rail Authority resolution said. Go for it. But didn't provide any evidence to support that go for it. The committee also received, through Mr. Walker, 2 written communications. One, an email from General Dayton, and that's Exhibit G to the Westby Declaration, and a letter from myself, Stuart Flashman, which is Exhibit A to the Flashman Declaration. And again, these 2 documents also were critical of going forward to authorize the bond issuance at that time. And both of them specifically said, you should wait until you know what's happened in the Fox case before you start moving ahead on this. So you have a lot of evidence saying don't issue the bond. You don't have any evidence presented. And again, in fact, plaintiffs have stipulated that other than the resolution from the authority asking for bond issuance and the draft resolution authorizing the bond issuance, there were no other documents provided to the committee in support of authorizing issuing the bonds. There was nothing, yet the authority had the ability, and it could have provided evidence, but it didn't. It just said, we don't need to. Just as the council was saying, they didn't need to. There didn't need to be any evidence. And yet, I think that under the hotel and motel association case, there did need to be evidence. And I think that, let me, again, under paragraph 6 of the Hamilton Declaration, again, that states very clearly that committee received no other evidence, heard no witnesses, asked no questions, and engaged in no discussion. And in fact, if you look at paragraph 7 of Ms. Hamilton's declaration, it states that once the public testimony was finished, the remainder of the meeting, the whole discussion and consideration of the bond determination took a total of 1 minute and 43 seconds.
What if the committee made a determination that the basis that was offered for not issuing bonds, the cost litigation, wasn't something that they actually talked about?
Well, there were a number of different reasons presented. I mean, toss.
But the committee hears that, and the
Yes.
committee decides that in fact they don't accept those as a basis for delay. Can't they reach that conclusion?
They could if they said, you know, we think that the evidence we have in this evidence outweighs the arguments of the toss case. If they had actually said something about saying, we're weighing the evidence and we think the evidence here in support of issuing the bond is stronger, that would be, they would have substantial evidence, and I think the court is well aware that when you've got substantial evidence to support a determination, that's enough. And the court doesn't reweigh the evidence and say, well, just because the agency decided there's more over here, we can't turn around and say, no, actually there was more over here. But there was no evidence.
Well, the resolution is evidence. The resolution from the authorities. There's a request there. It has findings in it.
It doesn't have findings. There's no facts stated. There's no whereas clauses. There's nothing in that other than the bare request for the funding.
You have a copy here? Between one and the other.
I can find it. No, that's good.
You have the same problem I'm having.
I got it here.
Sorry, guys.
Okay.
I found it.
There's nothing in here. It says, yes, it says, whereas, it basically says the bond was approved, the Bond Act authorizes bonds, it states that as a matter of law, the High-Speed Passenger Train Finance Committee shall determine the necessity or desirability of bonds, and it then says, whereas the authority desires to request the committee to authorize issuance of bonds. And it says the amount of the bonds. And it says the authority hereby requests the committee to authorize issuance of bonds. And it doesn't give any information as to why it's appropriate for the committee to authorize issuance of bonds. It just says, do it. And that's not evidence. From what I learned in law school, that's not evidence. And everything I've experienced as a lawyer since then, that's not evidence. So I think that the problem here is when you look at what was before the committee and how the committee made its determination, I don't think you can say that the committee's determination was careful, conscientious, or balanced. In fact, I think one has to say it was just the opposite. It was pro forma, it was slipshod, it was slovenly, and in fact, it was nothing more than a rubber stamp approval with no thought, discussion, or consideration. And given the way that, and again, this is documented, and we've got the transcript of what actually happened, we've got the actual documents that were before the committee. Given that documentation, I think the court has no choice but to look at this more carefully. The court can't simply defer to a committee whose members it knows nothing about their credentials, and to evidence that was non-existent. It simply cannot just refer to that and say, well, you knew what you were doing and you did it carefully, therefore I'm going to defer. And if the court is to say, all right, we need to, as the Supreme Court said, we need to penetrate more deeply, I think the result we end up having to come to is that there wasn't any evidence to support the determination. And that the determination was, in fact, even though it's a very hard standard, the determination was arbitrary and capricious and without evidentiary support. So the second point I want to make has to do with again, the acts that were required before the authority went ahead and issued the bonds. And that has to do with compliance with Government Code Section 16724.4. And plaintiffs have argued that the requirements of 16724.4 do not, if you will, kick in until bonds are actually issued and sold. And that's in plaintiff's reply brief at page 19. But that's not the case. If you look at what that statute says, what it says is the reporting requirement begins, and I quote, in the second year following enactment of the bond measure. Well, the bond measure was enacted in 2008. So the reporting requirement started in 2010. It's now 2013. There's no evidence in the record to indicate that the authority has submitted any reports. Indeed, I would have presumed that if they had, plaintiffs would have presented that evidence to the court. We haven't been able to find it, and it appears the plaintiffs can't either. So they are not complying with the requirements of the General Obligation Bond Act. And given that they're not in compliance with the Bond Act, neither they nor the public had the information needed to make a comment, to comment on or determine that it was appropriate to issue the bonds. The information was simply lacking. And from that standpoint as well, the bond issuance should not have moved forward. The certification of authorization of what the bond issuance should not have moved forward. And unless there are questions, I'll let Tom move.
Before you turn it over to Ms. Ross, I'll give Ms. Zook a chance to respond.
Thank you, Your Honor. Just as there's no precedent for overturning a committee's decision to use their discretion to delegate to members that stand in their behalf, there's also no precedent for overturning a committee's decision that bonds are desirable. We have to look at what the statute requires in this case. And the statute requires a request from the authority. It doesn't require that the authority make particular findings to the committee. It just says make a request. And they did, and I think that defendants' analysis of the request is missing the obviousness of it. The whereas clauses point out who the authority is, what their job is in terms of planning and construction. The fact that the voters have authorized these bonds for the planning and construction of this very project, and then they, again, the very weighty request to the committee saying that we want you to decide that bonds are necessary or desirable. This is a big ask. This is fairly obvious under the statute that issuing bonds would be desirable, but there's no ability to second guess that decision from the authority. That is within their discretion. If they want to make that request, they don't have to support it with particular findings. That is within their discretion. And what I said in the opening and what he said about the public comment issues shows not only the obviousness of the request in terms of the statute, but in terms of the need. No bonds had been issued while the Fox litigation was challenging bond validity. In order to get a validation determination, they would have to authorize bonds. And no bonds had been issued so far. This is something that the authority would have been well aware of. And it is within their discretion to decide if, given this information, now is a desirable time to issue bonds. The committee, when they get that request, They have to make a finding that it's necessary or desirable to issue bonds, which they did, but they don't have to explain their reasons. They don't have to conduct a hearing. They don't have to take evidence. They just have to make that finding. And again, it is within their discretion and not the place of defendant or I or the court to second guess whether or not they should have waited, done it earlier, later. That is within the discretion of the committee. With respect to the government code section 16724.4, I think this goes into issues we'll get into.
Before you do that,
Yeah.
what if the committee had flipped a coin as to whether or not they should make a determination? Would that be acceptable?
After receiving a request from the authority? Yes.
They had simply flipped a coin and said, heads is yes, tails is no.
It's within their discretion to make this decision. They had the evidence to make this decision. It's not with us. It's, I mean, this is, you know, they obviously didn't do that. But yeah,
I'm just trying to understand the
if
extent of their ability to make the determination.
as long as there's a request from the authority, they have the discretion whether or not they can decide it's desirable or not. So theoretically, I suppose if they decided this question's too hard, I want to flip a coin, it's not within our domain to say they should have made a decision for some other reason. But certainly we can't find that there's no basis for the decision, that it was use of discretion, and that we have to overturn it. Certainly that's not what happened there. With respect to the reporting requirements, they technically kick in, but there's nothing to report until there are uses of proceeds. But either way, this issue is moot because this has nothing to do with bond validity. Whether or not you meet a reporting requirement has nothing to do with the issue here, which is the debt valid, can it be repaid? There's lots of statutes that the high-speed rail authority will have to comply with throughout the project, which I'm sure we'll be talking about later. But they don't mean that a debt becomes invalid. They don't have to do with authority to issue bonds, authority to repay that debt. Those are separate issues.
All right, thank you. Mr. Flashman, Ms. Ross?
Well, let me just put in one more couple of comments on this first. And that is, I think that the issue that you asked about flipping a coin is really precisely on point here, which is, and I don't have a specific case site, but I know there are a number of case sites that make this point, and that is discretion that an authority or an agency or committee has is not absolute, it's legal discretion. And it has to be made on a basis that's legally defensible. And in this case, that means there has to be at least some evidence to support that determination. And the mere fact that they were asked to make that determination is not in itself evidence. If the authority had explained why they were making that request right now, what was the reason, then that would have been evidence. But just asking, in other words, somebody asked, can you give me a quarter? Is that evidence saying I should give them a quarter? No, it's just a request.
But if the original member said in there, you would concede that in fact they could have said yes, and that would have been...
They might have had the expertise to look at that and say, well, knowing what we know, and I would have expected them to have shared their expertise, because yes, it's true that, for example, the chair, Treasurer Lockyer, has a lot of expertise in terms of the state's finances. But none of the other members do. Each of them has their own expertise, but only if they have discussion is that expertise shared in such a way that they can all rely on it. If each of them is just in a capsule and not sharing any of their expertise with anyone else on the committee, how do the other people know that they can trust the expertise? And yes, Mr. Lockyer has a lot of expertise, but maybe this time he's making a mistake. Unless he shares that information as to why he's saying we should do it this way, how does anybody else get to evaluate whether that makes sense or not? How do we know whether he's actually using his expertise unless it's presented?
Would it be fair to say that your argument would essentially boil down to a question of delegation by the named members of the committee? And wouldn't it be fair to say that Zook's argument fundamentally boils down to unfettered discretion, unlimited discretion by that same committee?
I think there's also a question of evidence. What was the evidence? In other words, if there was evidence before the committee certainly would have had discretion to to say, based on the evidence we have before us, this is our determination. I do think that Ms. Zook's assertion that there is unfettered discretion is simply contrary to the case law on these sorts of administrative decisions. That a decision without any evidence is by its definition, like tossing a coin, arbitrary and capricious. And that's exactly what the law does not allow.
And Ms. Zook, would you agree with my summary that, in fact, Mr. Flashman's argument somewhat boils down to improper delegation, and your argument somewhat boils down to unlimited discretion?
No, I think his argument boils down to that he wanted the committee to explain himself, and that's not a requirement in the statute.
But I heard him also say that had the original members been there, had the named members been here, their known expertise would have been sufficient for them to have made a decision. Did I hear you say that?
Yes.
Okay, well, so that, I guess, is the two sides. He's either saying he wanted the original committee members to be there, but the statute gives him the authority to delegate someone else to act on their behalf. So he's saying under those circumstances, he wanted them to say the reason. That's not what the statute requires. I'm not saying unlimited discretion. They have to look at the request from the authorities before they decide if it's necessary and desirable. But he's missing the big picture in terms of the statutory framework, which is that the committee makes this, the authority makes this request. This has significance in terms of evidence. That is the most significant piece of evidence you could ever have in terms of is it necessary or desirable to issue bonds. Then the statute gives the committee discretion. They can ignore that request. They can decide they don't want to follow it. But the statute doesn't say they need to make specific findings, they need to conduct a hearing, they need to gather particular other evidence. They can consider what they want, how they want, in deciding whether or not to act on that request.
Let's move on to the second issue. Ms. Ross?
In the opening, plaintiff mentioned that the specific purpose of this is to create a high-speed rail project. And that goes in line with what the California Constitution says, because under Section 1 of Article 16, the state constitution requires that the work to be funded by a bond measure shall be distinctly specified in the proposed law that's presented to the voters, and that all monies raised by authority of such law shall be applied only to the specific object therein stated. The plaintiff also said that the specific object in this case is a high-speed rail project, and that's the problem. The voters approved a high-speed rail project, and based on what we have before us, that's not what they're getting. If you look at the statute, Streets and Highways Code Section 2704.01D defines high-speed trains as a passenger train capable of sustained revenue operating speeds of at least 200 miles per hour for conditions permit those speeds. When you look at the information in the voter guide that was presented to the voters, they were promised certain things. They were promised that they'd be able to go from San Francisco to LA in a certain time frame of 2 hours and 40 minutes. They were promised certain other things, and that's not what the voters are going to get. And because that's not what they will get is not a true high-speed rail system, the bonds cannot be validated.
Let me ask you a question. If you look at Streets and Highways 2704.04, notice the second line there. It talks about to initiate. Does that word have significance, the word to initiate, or the phrase to initiate, in the context of the bond? We're talking about bonds being issued to initiate construction.
Right.
There's at least an implication there that, in fact, they're moving towards something, but the bonds essentially are being issued to initiate movement toward that ultimate goal.
Right. And that goal is a true high-speed train system. the purpose of what the bonds are going to be used for is not what has not been approved by the voters, and so therefore it doesn't comply with the Constitution. So the judgment requested for validation has to be denied because under Pension Obligation Bond Committee, the all persons interested, the site for that is 152 Cal 4, 1386, and the pen site is 1406 through 1407. Invalidation of the bond issuance is really when bonds are going to be used for unauthorized purposes. Now, as argued, I won't go into all the things that were in our briefs because we've read it in the interest of time, but as the funding plan that the High-Speed Rail Authority has set forth, the most recent funding plan, it talks about how it's turning from a true high-speed rail system into a blended system, and that was something that was never contemplated by the voters. And because of that, if that's the system that they're going to initiate construction of, then that needs to be brought back before the voters, because that's not the specific object that the voters gave their assent to. They were promised certain things. When you look at proposition at the ballot template, which was set before the voters,
I do recall it.
it makes, like I said, it makes certain assertions of saying, you know, the trains are going to be able to go 200 miles an hour to 220. The funding plan says that's not going to be able to happen. They're not going to be able to go between San Francisco and LA within 2 hours and 40 minutes. They're not going to be able to do a ton of things that they were promised. And so it's going back to what the plan said about that there's no ability to second guess the authorities' requests and their instructions. We don't have the ability to second guess what the voters wanted because they told us this is what was presented to us, this is what we're agreeing to. The end, like that's the specific purpose that the funds have to be used for. Plaintiffs in their opening also brought up the federal government and having to report to them. I think it's important also to note that one of the things that the voters were promised in the election materials was that there would be oversight by the federal government and others such as the state legislative analyst's office. And the federal government has shown their concern with the fact that the plaintiffs have not identified any of the matching funds that are required by Prop 1A. In Section 2704.07 of the Streets and Highways Code, Prop 1A says that the authority shall pursue and obtain other private and public funds, including but not limited to federal funds, funds from revenue bonds, and local funds to augment the proceeds of this chapter. But as shown in Defendants' brief, the federal government, Jeff Simmons, who's the chairman of the House of Representatives Subcommittee on Railroads, Pipelines, and Hazardous Materials, that subcommittee has held plenty of meetings. They've stated and issued documents saying that the cost will likely continue to fluctuate. The project hasn't established any funding sources beyond the $3.8 billion of federal tax dollars and the Prop 1A money. They have plaintiffs are presuming that they're going to give us money, which it's not a guarantee. And that's something that's extremely important because the whole point of what the voters agreed to was that we weren't going to be putting our state into even more debt on a project that would never happen. So if plaintiffs cannot comply with the requirements of what the voters agreed to, the specific object of that purpose, then the bond validation, it has to be denied.
But is that a question for validation or a question for use of proceeds?
I think it's a question for validation because the use of proceeds as Clint noted, this is an interim action. So, under case law, any claims that could have been brought at the time that the validation proceeding takes place should be brought at that time or thereafter. So it's definitely, this is the time to bring it.
But the plaintiff in this particular action has conceded throughout that in fact those types of issues are not barred. Ms. Zook, I haven't heard you ever say that those issues were barred.
That's correct.
There's a problem with that is they keep saying that they're asking for this narrow release, but if you actually look at the release they're requesting, for example, in the proposed judgment, they're actually asking for extremely broad release that has the potential to bar future claims. And also, I would argue that defendants and all persons, defendants are entitled to rely upon what is potentially an erroneous interpretation of the law. I mean, case law says that this is something that needs to be brought at this particular time. I'm inclined to go with what the cases say over what plaintiffs are saying when it comes to this matter.
Would you argue that if the bonds were validated, then the Toss action questions that still exist would be precluded?
I don't know. I honestly, I would argue that the two cases probably should have been consolidated.
But to the extent that they're not, if the bonds were validated, how would that affect the issues in the Toss case?
Yeah, that's the question.
But isn't your argument that in fact validation would preclude those issues?
Well, the problem with that is that those issues have been brought up before the validation. So that's a question of timing, and I'm not sure that there's any case law on point. So on that issue, I would have to defer to counsel on the cost matter. But yeah, I mean, that's the timing issue of it. It was brought before the validation, so I can't say for sure what impact that would potentially have. I can, however, say that not only has the federal government expressed concern over the potential funding problems, but the statutorily mandated peer review group has asked for caution with regard to this project, as has the state auditor's office. And in fact, the state auditor has made several recommendations which the plaintiffs have yet to fully implement, at least as of January of this year. The plaintiffs have argued that they're not required to do so, but it goes back to the same idea as the evidence, the lack of evidence when it comes to the meeting that Mr. Flashman is talking about. At what point are they actually required to do anything besides say, we want to do this, let's go spend everyone's money? You know, if they're spending it on a project that's not going to be what the voters agree to, they're in violation of the Constitution. That's number one. Secondly, they run the risk of having a project that never ends up getting completed. And it's, instead of it being like the little engine I could, where they're like, I think again, it's essentially becoming this giant train wreck that can't do anything what it's supposed to. It can't comply with the voters' intent. It can't comply with the Constitution. They can't even comply with the elements of the statute at issue.
But you're back to the original issue. Should the authority, in effect, be allowed to put the money in the bank? It's a little bit of a different issue from should the authority be allowed to spend money from the bank? No,
not at all. And not until they come up with a funding plan that actually complies with the requirements of the statute. The problem is that the project that they want to initiate construction on at this time, that they want to put the money in the bank for, does not comply with that. In the event that the high-speed rail authority can come up with a funding plan that complies with Top-Way and all of its requirements, then yes, perhaps at that time they should be able to put the money in the bank. But the problem with putting the money, with the analogy of putting money in the bank is, when you put money in the bank, you draw interest. They're not using it, we're going to end up losing money because of it. So I would say that shouldn't even be an issue until it's shown that they can comply with the terms of the statute.
All right, let me interrupt you. Zook, can you respond?
Yes. Article 16, Section 1 of the Constitution that council is referring to in terms of it has to be in order to satisfy the constitutional debt limit, you need to, there's a number of requirements, but one is that the statute is, in this case, put before the voters and voted on by the legislature has to specify an object, so here it's high-speed rail. And then the actual debt has to be for that specified object. That's a different issue. In this case, we complied with that because the Bond Act says for purposes of high-speed rail, and the resolution says for purposes of high-speed rail. The issue that council is talking about is if the bond resolution itself on its face had been not for what was authorized under the Bond Act. So if the authority had asked for and the committee had granted a request to build, for bonds to build a carousel or something like that, that's clearly in violation of the Constitution because they don't have the authority to issue that debt. The pension obligation bond case was not, use the proceeds case. It was again in violating the constitutional debt limit. It was had to do with a different exception, whether or not they applied and didn't need voter approval. We are past the debt limit issue in this case, and use of proceeds under the Bond Act. I understand Council's point, but money in the bank versus money out of the bank under the statute, those are different issues. There is no requirement that the funding plan be in place in order for bonds to be valid. In fact, even if the funding plan is invalid under the statute, the bonds are still valid. These are separate issues. The statute is designed so that bonds can be issued, and then these use of proceeds issues can be sorted out later in terms of compliance, like state auditor, funding plan. All of those issues happen down the road because the bonds are also for design, they're for administrative costs, construction along the way. The questions defendants are posing in terms of design requirements or reach a certain speed, those can't be answered at the time that bonds are initially issued. They're essentially saying, bill us the project, we'll see if we like it, and then I guess send a receipt, and that's not how it works. Under the Bond Act, the bonds are valid before these issues are sorted out, and there's a large body of case law where people bring challenges to projects like this after bonds have been issued, and they say, no, you can't use the bond proceeds for this thing that you want to do here because we don't think that was authorized to do that. And those, as we've said throughout, are permissible claims. They're not barred. To complete another issue, which is that this is an interim action. So there's a matter at issue, which is bond validity. The authority can also validate contracts. So sometimes contracts have to do with the proceeds. But that doesn't mean that if the matter at issue is bonds, that's going to affect contract. If you have a contract, if they wanted to challenge a contract later down the line, there could be an issue of whether or not those claims needed to be brought within 60 days of the contract, but not within 60 days of the bond validation. It has to do with both bonds and certain contracts under the validation statute. Challenges need to be brought within 60 days, and there's not necessarily a relationship between one or the other. And again, I think part of the confusion is that in this case, these are general obligation bonds. Some cases involve contracts that are part of the financing scheme, so the bonds in the contract are authorized at the same time, so you see challenges to those at the same time because of the 60-day limit.
We're going to take a 15-minute recess. See you all back here at 10:45.